Hello, in this video we will continue our discussion about personal jurisdiction, and we will focus on personal jurisdiction in tort cases. In those cases, when a non-resident person has committed a tort in relation to Australia, the courts will find jurisdiction over a person non-residing in Australia in that case when the tort occurred inside of the territory of Australia. This is so-called lex loci delicti rule, and it looks at the place of where the tort occurred. In online environment, however, this rule causes some problem. Mainly, it poses the question where tort occurs in online environment. Is it a place from where defendant acted? For instance, if defendant acted from United Kingdom, will Australian courts have no jurisdiction even if the conduct can be felt, the content could be accessed in Australia? Is it the residence of the right holder or plaintiff? Is it the place where the content can be accessed? Or does the tort occur in the place or in the country which extension of a domain name is used, such as com, .au, .cn, and so on? One last alternative could be finding tort occurring in the place where the server containing the alleged infringing information is situated. The answer to this question has been given in a famous case, Gutnick versus Jones Corporation. In the case at stake, the United States company was publishing a journal called Barron's Magazine. It published some allegedly defamatory material about Australian resident Mr. Joseph Gutnick. This journal was sold both offline and online. Around 305,000 copies were sold, of which only 14 copies were sold in Victoria, and the journal had around 550,000 online subscribers, of which only 300 were in Victoria. Mr. Gutnick, Australian resident, sued the United States company Dow Jones in the Victorian court, arguing that Australian law has been violated and his reputation was damaged. The question before Australian court was whether court can establish personal jurisdiction over US-based company Dow Jones and Company. In particular, they were asking where did defamatory publication online occur. The defendants were arguing that publication occur in the place of server that is in United States, unless this server were completely adventurous or opportunistic. The defendants were arguing for single publication rule that is applied in United States. The rule allows jurisdiction only in one court, that is the place of server, and in this case diminishes the risk of publishers of being sued in multiple jurisdictions. On the other hand, the plaintiff, Mr. Gutnick, was arguing that the courts would have jurisdiction if the particular defamatory content can be accessed in their territory. That is, since defamatory material was accessible in Australia, Australian courts would have jurisdiction over the website run from United States. Australian court, namely Victoria Supreme Court, looked at the balance of interests of different parties, looked at the need to preserve publishers' interest of legal security and freedom of speech, that is, publishers' interest not to be subject to multiple jurisdictions worldwide, but rather be able to comply with the laws with one jurisdiction only. On the other hand, the court looked at the need to protect individuals' reputation, in this case, reputation of Mr. Gutnick living in Australia. Looking at this balance of interest, the court decided that defamation occurs in the place where damage to reputation occurs, namely in the place where defamatory material is downloaded. In the case at stake, there were several downloads in Australia, and this was sufficient for court to establish that Australian courts have personal jurisdiction over the defendant. The courts denied single publication rule is applied by United States courts, and this was harshly criticized by publishers. On the other hand, they reinforced the possibilities of persons living in Australia to protect their reputation that has been harmed by different material published in websites abroad. Thank you very much for your attention. In next video we will discuss foreign nonconvenience doctrine.